Welcome back to the Law and Crime Network. I'm Heather Hansen, and we are watching replays of the past few weeks of this case against Tex McIver. It has been a fascinating case, with the prosecution sort of having its ups and downs with regards to whether or not they really seem to be making a claim or whether they seem to be sort of pulling at straws. And I want to bring in our fabulous guest who we have on via Skype today, Charles Mittelstadt, who is a criminal investigator, and here with us to talk a little bit more. I know, Charles, we've had you on before, but it's so great to have you here and talk a little bit about what happened last week. Good morning.
Good morning. How are you, Heather?
I am great. It's good to have you here, Charles, especially given the testimony that we saw late on Friday. And that was the main detective who investigated this case being called by the prosecution and yet, in many ways, being attacked by the prosecution. Have you ever seen anything like this?
Remarkable. I mean, truly remarkable. And this is actually, I mean, this happened on a kind of an extreme level. We've seen it happen a little bit earlier in the trial with some other witnesses on a smaller level. But this is the lead detective in a homicide case, and here the prosecution is actually attacking their own lead investigator in the case, trying to point out deficiencies with his investigation, actually trying to impeach him based upon other prior statements that he's made. Truly, truly remarkable.
Yeah, it really struck me because so often we see defense attorneys doing this and attacking these investigators and attacking their findings. And I think the defense attorney actually said, you know, can you believe that I'm the one who's supporting what you're doing here? How do you think something like this plays to the jury, Charles?
I don't think it plays well for the prosecution. I mean, the fact that they've had, let's keep in mind, this is their case in chief. They're the ones who are supposed to be putting on their strongest witnesses, their strongest case, and it's supposed to be made very, very simple. I mean, a lot of this evidence that favors the defense isn't supposed to come out until the defense chooses to put on a case. But consistently throughout this trial, we've seen them score points on prosecution witnesses, getting them to acknowledge that they thought it was an accident, getting them to discuss how in love Diane and Tex were, and now in this case you have the lead detective who's saying that basically the DA's office has overruled the recommendation of the Atlanta Police Department in this case. I mean, they pursued this as an involuntary manslaughter case, and somehow the DA's office is just taking the position that they have some sort of superior wisdom, and they're going with this. I don't think it bodes well for them.
I agree with you, though I do have to say, Charles, I was struck by the number of questions that the investigators did not ask. And as you know, I mean, a lot of pretty basic questions. And isn't that the crux of your job, is to ask the right questions to get the answers that you need to make a case?
No question. I mean, there are some basic questions that were not asked. Even something as simple as, do you recall pulling the trigger, or was the gun cocked? I mean, these are some fairly basic questions that Detective Smith didn't ask. So, in fairness, there clearly were some deficiencies in his investigation. But on the other hand, he also talks about the fact that he did look at the finances and he didn't see any sort of motive from that standpoint. I mean, there were some shortcomings, but at the end of the day, it's a really unusual and extraordinary position to be in for the prosecution to be taking such an oppositional position towards their lead detective in the case. I mean, it's remarkable.
Yeah, it really struck me as well. I want to sort of hone in on the thing about the gun that you just said, because you and I have talked about this before. But ultimately, this case in many ways comes down to the difference between 2 pounds of force that would have been needed if the gun had been in one position and 12 pounds or so that would have been needed in the second position. Do you think that that's really the crux of the case here, Charles? And if so, has the prosecution done anything to move the ball forward to meet their burden there?
I do think that is really the central question. I think the jurors are going to have to come to grips with the fact that if they're going to believe, can you hear me?
Yes, go ahead.
Okay, if they're going to believe that it's accidental, then they're going to have to buy into this notion that it was, in fact, in the single action mode, which is the 2¼ pound trigger pull pressure. It's hard for me to conceive that in the double action mode, which would have required over 12 pounds of pressure, that could be considered accidental. It's very easy in the single action mode to have, for Tex to have brushed his finger against the trigger. He didn't even have to have his finger in the trigger guard, but really is such a light trigger, truly a hair trigger at 2¼ pounds, that just brushing up against the trigger would have been sufficient to do it. And as the GBI's firearm expert had to acknowledge, there is no expert ever that can rule out the possibility that this was unintentional. So that's a huge statement for them to have to concede to.
Yeah, it's very difficult to overcome reasonable doubt when they've made that type of admission. But it is interesting, and sort of, in many of the cases that we cover here, we see where the police officers' work, the investigators' work is being questioned and sort of brought to question, usually by the defense attorneys.
Right.
In these types of cases, Charles, is it really difficult to dot every I and cross every T? It seems as though in every case there's something to point out, and it seems to me as though if anyone were to follow us around in a day's work, you'd certainly see I's undotted and T's uncrossed. Is it something that simple, or is it a situation where our investigators don't have the resources? I mean, why is it that almost every case, in this case in particular, you're able to look at the case and say, well, the investigators didn't do this, this, and this?
Well, I mean, because the criminal justice system is administered by human beings, and we're flawed. And so on every level, there is the potential for mistakes. And so that's really what my job is. My job is to come behind and actually look for those mistakes. I'm looking for reasonable doubt. I'm looking for questions that weren't asked. I'm looking for interviews that weren't conducted. I'm looking for evidence that wasn't collected or that was tainted in the process of being collected. So it's, I kind of get to play this sort of armchair quarterback role where I come back in a perfect world where I'm well funded, I have more time, I have more resources to investigate. But in fairness to law enforcement, it's a very difficult job. I mean, most homicide detectives are overassigned, understaffed, and sometimes undertrained. They just haven't had the chance to go for reoccurring training, and so that's how these mistakes happen. They have a lot of pressure on them to clear a case, and they're also human beings. They develop a theory in a case, and they start, unfortunately, they have tunnel vision. They look for evidence that just suits the theory, and they kind of ignore some of the more exculpatory stuff, and then they wind up in this sort of situation. I don't think that's what's happened with Detective Smith. I think that's actually what's happened with the prosecution in this case, that they developed this theory, and it seems to be at the exclusion of everybody else who's looked at the case so far.
Yeah, Charles, I think it's interesting to your point about your job and going back and sort of looking for the mistakes after the case has been done. I'm wondering, has there ever been a case where you have found not a single mistake to point to? Or is there the situation that in every single case you can find at least one thing for the defense to sort of rest their hats on when they're trying to argue reasonable doubt?
Well, I can't say that there's been, like the perfect case, but, it's not unusual for me to find some flaws that ultimately don't really amount to anything that's going to make the case more favorable for the defendant in the case. So you're always going to find little things you can pick at. But at the end of the day, my job is to look for the good, the bad, and the ugly. And I'm not an advocate. I'm a fact finder. And so my job is to help put the defense attorney in a position where he or she can properly advise their client based upon the real merits and strengths of the case, so that they can make an informed decision about whether it makes sense to move forward with a trial or to try to negotiate some sort of plea and deal with real facts. I mean, the last thing you want in a case is a surprise or surprises, and so that's why I encourage clients to be as honest and forthcoming with me as they possibly can. I tell them there's no judgment, nothing I've never heard or seen before. Just let us know now. Don't let us get caught with our pants down or surprised later, because ultimately it's going to be at your expense. Well,
that's right. And here, I think one of the things that has struck me throughout the course of this case is there's a lot of inconsistencies for the defendant, Tex McIver. A lot of things that he said that he maybe shouldn't have said, and then talking about not being so interested in firearms, and then the prosecution bringing forth all those firearms. Are those the types of things that you worry about when you're trying to do your job, where, as you said, you don't want to be caught with your pants down? You don't want to be in a situation where you're losing credibility, especially when it's not necessary.
Absolutely. I mean, from the beginning, I think that has been the challenge in this case. It's not the physical evidence, it's not the ballistic or the firearm evidence. It's actually Tex's own actions, his own words that are the Achilles heel of this case. These are the things that are providing the challenge to the defense. And listen, even I think the case has gone exceedingly well for the defense so far, yeah, as it relates to the murder charge in this case. But when it comes to the witness tampering, we're going to see what sort of defenses they put up for that. But there are some problems with regard to some of his actions immediately post-incident and some of the things that he said and voicemails that he left and so forth. Whether that makes him, I don't believe that it rises to the level of proving any sort of motive or that he actually premeditated this. To me, it's more in line with someone who's overthinking and concerned about controlling spin and that sort of thing, and is engaged in some really poor judgment. Hopefully, for the defense, the jury can see through that and sees it that way. But nonetheless, there are, with regard to these other charges, other than the murder charge, I think he still has some significant exposure on those.
I couldn't agree with you more about Tex McIver trying to control the situation and having that ultimately come back to be the thing that's probably most problematic for him in the case. Do you think that that's the result of his being an attorney? When you're working with defendants, do you see that people who are actually in the system try to control the facts and try to control the narrative even more than those who perhaps have no exposure to the system?
100%. I've had numerous cases over the last 25 years involving attorneys as defendants and politicians, two professions that require you to be a great orator, to be in front of a crowd, to speak publicly, and to be able to control spin and narratives. And these tend to be the types of individuals that most want to free themselves, most want to talk their way out of a particular predicament they may be in, and they really should just follow their own advice that they would give to a client and exercise that right to remain silent and let their attorneys evaluate the case from as a uninvolved third party who doesn't have the emotions that the defendant may have in the case. And he failed to do that. And consequently, he did things like the jailhouse interview he did and some other actions that he took that ultimately are going to present the greatest challenges to his defense.
Yeah, I couldn't agree with you more. I think it's a whole lot easier to give advice than to take it. And so often you see people who, and especially for lawyers, my mentor was an ex-DEA agent, so he had testified before, and he often would remind me that being in those situations, being questioned by the police, being asked to be deposed, being on the stand and testifying to a jury is a whole lot different when you're the person in that seat. Do you think that for Tex that he's going to be able to, or his defense team will be able to overcome the witness tampering charge? Because I agree with you, Charles. I think that going to the defense case, to be in the position they are with regard to the murder charge, I would be feeling pretty good as a defense attorney. Not so much with the witness tampering, though. What do you think is going to be at play there when the defense puts on their case?
Hopefully they have some sort of a legal argument to deal with one or two of these. There's 3 witness tampering charges. The voicemail that was left, that one I think is a challenge. I just don't know that you get past that burden on some of these charges. I do think that's a significant challenge for him.
Yeah, I agree with you. The other thing that I thought was interesting with regard to the investigator who testified last week, Detective Smith, the jury questions. I always am very tuned into jury questions. Number one, because where I practice, we can't ask them, so I'm always interested to see what they say. But number two, it does give you a sense where at least some of the jurors' heads are at. And the jury questions, first of all, were with respect to Detective Smith's experience. So they asked how many years he had been on the force, and they asked how many homicide investigations he had done. What did you think of those questions?
Well, they want to know how reliable his investigation is. I think that's, points to the fact that it's a very thoughtful jury. They're not just going to rely on Clint Rucker's attack of him and automatically assume that he did a lousy job and that he lacks the experience to have done a thorough investigation. They want to try to make that determination on their own.
Yeah.
And so I think that's, that points to the fact that you have a very diligent jury who's paying attention to the evidence. And if they are paying attention to the evidence, I think that actually favors the defense as it relates again to the murder charge, because I really think to this point they've fallen well short. The buildup, you could see the flow that the prosecution has attempted to get in terms of the kind of the slow buildup, especially with the financial witnesses. Those were sleeper witnesses, but it was all the buildup to getting to the firearms experts, because that's really ultimately what this case comes down to. And so they wanted to get some of that slower evidence out of the way. The firearms experts and the GBI experts with regard to gunshot residue and all that, again, at the end of the day, it really comes down to the fact that it's that last, phrase is that no expert can tell would ever be able to testify as to the intentions of somebody pulling the trigger in this case. So it kind of leaves them really back where they started. And could it be accidental? Absolutely. Right. Could he have had intentions? Absolutely. We really haven't, the prosecution hasn't necessarily, moved the ball too far towards the goal line much further in the last week.
I agree with you. In just a minute, I want to go to a break, Charles. And when we come back, I want to talk to you about all the physical evidence that this jury has seen in this case. But before we do, I do want to talk about the last question that the jurors asked. And that had to do with when questioning Danny Joe, apparently Detective Smith said something about it being an accident. And Detective Smith's response to that question was that had he started saying that perhaps Tex McIver was guilty of murder, it would have changed the tone of the entire interview. And I'm wondering, in your profession and your job as an investigator, do you try to set the tone during these interviews to make sure that you're trying to get as much information as you can from the people that you're interviewing?
Absolutely. I mean, I think that's a fair response by Detective Smith. I mean, the key to interviewing is to, especially in a cooperative interview like this, is to develop a rapport with the subject of your interview. And listen, cops lie all the time as a matter of tactic during interrogations and interviews. And so they'll tell generally the prospect what they want to hear in order to keep them talking and try to elicit as much information as they possibly can, or catch them in a lie or whatever. So the fact that he chose to adopt that sort of approach with this witness, given that she is a friend of Tex, I think is entirely reasonable. And frankly, to me, it's good interviewing technique.
Charles, if you have time, I'd like you to stick around a little bit so that we can come back and talk a little bit more about the physical evidence. In the meantime, we're going to throw to a couple more clips of Alan Craig Stringer. This is one of the friends of the deceased, the victim, as he talks a little bit about his interactions with the couple before that fateful day. We'll be back in just a minute with Charles.
1 hour after I started working for him.
Okay. And where did you fit in the hierarchy at U.S. Enterprises in relationship to Diane McIver?
I was number 2. I mean, she was the president of all companies, and I was vice president of all the billboards and whatever she wanted me to do.
Okay. And can you tell the jurors just a little bit about the kind of relationship that you and Diane McIver fostered through the years?
Sure. When I started with the company, I was told that they had just sold to Clear Channel for $48 million. And I was told that 4 salesmen, 5 billboards for sale, a vice president of sales, and a marketing director. And when I came on board, I was told that if I sold those 5 billboards, I would be made vice president of the company, of which I did, and my next job was to fire everybody. I would say our relationship almost was like brother and sister, from the standpoint of we'd holler at each other all week long and play golf on the weekends, and it was almost like there was this is this and this is this. We don't mix the two. We have our pleasure playing golf. We go to work on Monday morning. Very strict in that area also.
Okay. Now, what does you mean that you and Diane McIver would holler at each other? What does that mean?
We would holler at each other.
About what?
Anything. If she thought that I did something I wasn't supposed to do, I was like a child and corrected. And I shut up.
Okay. And were you the only person that you ever observed that kind of attitude from Diane McIver?
She told me personally, she says, Craig, I have never let anyone in the company into my personal life like I have you. She said, respect it.
Okay. What did Diane McIver drink in your presence?
Diane never drank while we played golf.
I understand.
Wine. At dinner, wine.
Wine.
Yeah.
White wine, red wine.
Wine. What's the most popular wine at the moment that everybody's drinking?
Okay. But when you saw her drink, what color was the wine that she drank?
Every color.
And so what?
Mostly white, but every color.
Okay. Does that include red?
Chianti's red.
Okay. I just need you to tell me. Okay. How about the defendant?
Same thing, basically. He liked red wine better than white, I believe.
Okay. And you've seen this with your own two eyes, correct?
For all the years that I was with him, yes.
Okay. Now, did there come a point in time when you stopped drinking?
8.5 years ago, joined AA.
And as you sit here today, are you a recovering alcoholic?
I'm continuing to recover.
Okay.
Haven't had a drink in 8.5 years.
All right. Congratulations.
Welcome back to the Law and Crime Network. I'm Heather Hansen, on with Charles Mittelstadt, and so happy to have him here because he has such phenomenal insight into so many issues in this case. I could talk to him all day, but we don't have all that much time, so I want to make sure that I get to some of these issues. Charles, first of all, one of the things that the prosecutor has done well in this case is to recreate a lot of the scenes here, visually, but also with the ability to see things in 3D and touch things. They recreated the SUV. They've brought the 40 guns and unloaded them onto the table. How do you think that they've done with that? And do you think that that's an effective way to sort of get the jury more invested in the case?
I think so. I think they have done a very good job with that. Again, based upon the evidence itself, I don't know that it's going to win the day for them. But the physical recreation they did by bringing in the seats and all that, I thought was very good for them. But it also gives the jury some insight into the spatial issues. And also they have a good chance to look at the level of the gun, of the entry hole into the back of the seat. And it also happens to be very consistent with the defense's claim in this case. The 3D recreation, I thought, was somewhat prejudicial in favor of the prosecution, because it doesn't have doors on it. And, I think the prosecution benefited from that particular recreation. But at the end of the day, again, the jury has to decide if this was intentional and premeditated and he was going to claim some sort of accidental shooting, then why wouldn't he just shoot her in a more vital area in the head or something? Why would he just rest the gun at lap level and take one shot through a seat that he didn't know whether it would actually penetrate or not based upon the inner workings of that seat? So it's seen, and why would he do it? Is in close proximity to a bunch of hospitals as opposed to somewhere in an isolated area where they've been traveling earlier. He didn't know they were getting off the expressway at that point. So the prosecution has to deal with the fact that based on their theory, his intent would have had to have formed like almost instantly, based upon that change in route. So there's a lot of challenges there still for the prosecution.
Yeah, one of the things that I think of when the prosecution has been putting forth all of this, the recreation of the SUV and bringing in all these guns, is all sizzle, no steak. They're really putting on a very interesting case and trying to make it as engaging for the jury as possible, but sort of maybe to overcome the fact.
Where's the beef?
That's exactly right.
Right.
We'll be continuing to ask, where's the beef from the prosecution,
right,
perhaps all the way through until the jury goes out to deliberate. One of the things, though, that is effective, and I just double-checked, we were talking about this offline here a little bit, Charles, is the jury, it does seem as though the judge has decided that the jury is going to be able to handle that gun. that may be helpful to them as well to sort of see the difference there between the 2 pounds and the 12 pounds. However, as a layperson who's never personally handled a gun, I would worry that these perhaps lay people would come to conclusions that are not supported by actual experience with guns. Would you have that concern, being someone who knows guns pretty well?
Well, I think it's a double-edged sword. So I think the jury will seize greatly on that opportunity, and what they're going to experience is that there is a tremendous difference between the 2 1/4 pounds and the 12 1/4 pounds. And invariably, the only way that I think the defense can sell this notion that it was accidental is if it was in the single action mode, which is the 2 1/4 pound trigger pull. And they're going to get to see that's very, very light. But the Achilles heel there for the defense is that really almost makes a reckless conduct case against Tex McIver. Why would you be sitting in the back seat with a loaded, cocked gun? And especially with the alcohol issue that really is just now starting to be explored. I think the juries have seen from the photographs that there was a bottle of wine in the back seat, back pocket of that seat. And they've also heard from Stringer and others that there was some drinking that occurred. But now you heard for the first time Clint Rucker, during his examination of Detective Smith, get into this alcohol-related, this is particularly potentially an alcohol-induced event here. And naturally, the defense wants to stay away from that because of their concerns for defending a reckless conduct charge.
Well, let's talk a little bit about the lesser included offenses, because that's really what you're talking about here, that even if the jury, as long as the prosecution asks for them to be included, which one can't imagine that they wouldn't, even if the jury doesn't find that this was intentional because of all the things that you so succinctly pointed out, they could in fact find involuntary manslaughter or recklessness here. How do you think that will sort of play out, and do you think that the prosecution will recognize that everyone's saying, where's the beef, and will start to sort of rest more upon the use of alcohol, the fact that he was sitting there in the back seat with this gun practically ready to discharge, and all of the other little things that support the lesser included charges?
Absolutely. And that may have been their strategy from the beginning, is let's shoot for the moon with this murder charge, and then let's give the jury kind of this compromise verdict where we give them a reckless conduct, involuntary manslaughter charge to chew on. And while I understand they have not asked for that yet, I'm confident that they will ask Judge McBurney to include those lesser includeds. And to me, it all but guarantees that he gets convicted of those charges based upon the evidence that I've seen so far. Yeah. So that is the challenge for the defense, as I pointed out a little earlier, is they don't want to get into the alcohol too much, because handling a loaded, cocked gun while intoxicated or in some altered state is reckless, especially from someone who we've now heard from multiple witnesses, a very experienced gun guy, and they brought all those guns in to show the jury exactly how experienced he is. He's practically a cowboy. I mean, if you look at this, and he goes by Tex. I think I would have been addressing him as Claude if I was the defense. But there's even a sign on the front of his ranch that even talks about the guns. So it's a challenge for sure.
Charles, you have such good insight to jurors' minds. You've got to be a phenomenal asset to the teams that you work with, because I agree with you. I think that, in this case, the jurors don't have to know that he's Tex, and that certainly gives a different perspective and a different idea in your mind of who this defendant is, as opposed to Claude. I think that would have been a smart way to go at it. The other thing that you mentioned a little bit earlier with respect to this alcohol thing is Tex's alcohol was never tested, which in and of itself may have been an issue for the investigators. Is that something that you would have expected them to do, given the fact that they were talking, he's the one that actually shot the victim?
You would think so, but the jury is going to be able to have what I would consider to be some sort of baseline, because we now know Diane's alcohol level, which I believe was 1.4, which is above the legal limit if you're driving, well above actually. And so because of that, I think the jury will infer that Diane and Tex might have been similarly situated in terms of their alcohol consumption, because they were drinking at Longhorn and in the car, and that's in fact why Danny Jo was driving, right? Because she wasn't drinking or hadn't had as much to drink. So I think they'll probably make an assumption that he had a similar alcohol level.
Yeah, and I think that your point is a smart one, that perhaps the prosecutor is a whole lot smarter, playing this a whole lot more smartly than we had thought they were, in that aiming for the moon and then landing among the stars with these lesser included offenses, so that the jury, even if they think they're giving the prosecution something that, a loss, in truth, the prosecutor may be getting exactly what they wanted all along.
Yeah, where's the harm in shooting for the moon? If you actually get a murder conviction, I mean, they've certainly put the work in. They're trying very hard to secure that sort of conviction. I think they're coming up well short at this point, but in the process, they're making a pretty compelling reckless conduct and involuntary manslaughter case against him.
Well, Charles, I cannot thank you enough for coming on with us today. I know that your insight is really important to our audience as we especially as we weigh the investigation in this case and the pros and the cons of how they went about it. So I've got to thank you again for being with us. I know we're going to ask to have you back many times as we finish up this really interesting trial.
My pleasure. Thanks, Heather. Have a great
Charles.
day.
You too. All right, ladies and gentlemen, we are continuing to look at some of the witnesses in this case, and specifically some of the witnesses who had interactions with the couple, with Tex and Diane, right before the night when she was shot in the back by her husband. We want to go back to Alan Craig Stinger, who's one of the people who worked with Diane. And we've heard from some of these people as we've listened today, and we're going to continue to hear about their relationship, about the days leading up to this event, and about what the motive may have been for Tex McIver. So we'll be right back after this clip.